today, so I apologize. So this is on the anatomy of a civil tax controversy. Just a little bit about me. So we're going to cover a number of topics in this webinar. We're going to start out with a broad overview of the civil tax controversy process, and I'd like to call it the anatomy of a civil tax controversy. And there definitely is a beat or a certain rhythm to the audit process, and if you're on the receiving end of it, it's by no means a soothing beat. It's much easier, of course, to go through this with an experienced attorney who's also a good advisor. And this is, again, a very general overview, and I've reduced it to steps just so that you can, conceptualize it, and then we'll go into a bit more detail. In step one, the IRS conducts a tax audit. Now, everybody has a different interpretation of what this means, but the technical definition of a tax audit is that it's an examination of the taxpayer's income and expenses to ensure that the taxpayer correctly reported his or her tax liability. All types of tax returns are subject to audit, whether it be income, business, estate, and gift tax returns. In step two, an examination results in three possible determinations, and here you see them listed. First is an increase in the taxpayer's liability. Second is a decrease to the taxpayer's liability, which rarely, if ever, happens. And third, no change whatsoever. Upon completion of an exam, let's suppose that the revenue agent determines that a deficiency exists. We are all familiar with this term deficiency, but it has a precise meaning, and it's defined as the taxpayer's correct liability as determined by the IRS. So correct is more or less the term that would be used by the IRS, less the amount reported on the return. So again, it's important to have a solid understanding of that definition. It is the taxpayer's correct liability as determined by the IRS less the amount reported by the taxpayer on the return. Assuming there is a deficiency, the agent will prepare what's called a revenue agent report, an RAR. Included within the RAR is a cover letter and a proposed settlement agreement. The taxpayer who disagrees with the revenue agent's findings may request a conference with the IRS Appeals Division, but there is a time limit. He or she must do so within 30 days. So what we call a protest to appeals. If the taxpayer disagrees with the agent's findings, then they have to file a protest within 30 days of receipt of the RAR. It's for this reason that the cover letter is also known as a 30-day letter. Now, the taxpayer who receives a 30-day letter faces a strategic decision, and that decision is between requesting a conference with IRS Appeals or doing nothing. And I'll discuss with you what going down each path, the consequences of going down each path. Let's suppose in step three that the taxpayer requests an appeals conference, but the parties don't come to an agreement. Or let's suppose that the taxpayer simply ignores the 30-day letter. In both cases, the IRS would send the taxpayer a notice of deficiency. And the notice of deficiency has a nickname of 90-day letter. The notice provides the taxpayer with two options: pay the asserted deficiency and follow the refund procedures, or petition the tax court to contest the claimed deficiency. And if the taxpayer decides to dispute the asserted deficiency through this petition process, then he or she has 90 days from the date the notice was mailed to file the petition. And these are hard and fast deadlines that I'm giving you. When we talk about the 30 days the taxpayer has to file a protest to appeals, after receiving the RAR, and when I talked to you about the 90-day deadline the taxpayer has to file the petition with tax court, again, these are hard and fast deadlines. If they're missed, there is no recourse. The mailing of the notice begins a period during which the IRS is prohibited from assessing tax. Now, in step 4, we're going to assume here that the taxpayer files a timely petition to the tax court. And assuming he does, what he can do is he can challenge the deficiency. Remember what the deficiency is: the amount that the IRS believes that the taxpayer owes minus the amount that the taxpayer self-reported. So if the taxpayer timely files his petition, he can challenge the deficiency claimed by the IRS and any overpayment claimed by the taxpayer. The IRS is barred from assessing tax until the tax court's decision is final. We're going to shortly get into what is meant by an assessment, because an assessment is another very specific legal term of art. Now, I'm going to get into, what I like to do is get into some practical areas with you so that you have a general idea of what to expect if you're representing a client in tax court, or if you find yourself as a petitioner in tax court. Who represents the IRS in tax court? Contrary to popular belief, it's not the revenue agent who gave the taxpayer a hard time throughout the audit process. The IRS is not represented by the revenue agent. Instead, the IRS is represented by an attorney from IRS Chief Counsel's office. Now, while the IRS is represented by an attorney from Chief Counsel's office, the taxpayer does not have to have an attorney representing him or her in tax court, so long as the person is certified to appear in tax court and licensed. It can be a tax preparer, it can be a CPA, it can be an enrolled agent, it can be anyone who has passed the requirements for practicing before the U.S. tax court. So it doesn't have to be an attorney. Most taxpayers, however, prefer to have an attorney because sometimes these cases actually do go to bench trial. And in those cases, the attorney has the experience and has the training of, of being in an environment and a setting where they are cross-examining witnesses, conducting direct examinations, introducing evidence, fighting to keep out evidence, all of the typical things that happen in a court of law. However, the U.S. tax court does have its own unique set of rules and rules of evidence. As a general rule of thumb, these individuals, specifically IRS Chief Counsel's office attorneys, are more likely to make some concessions to reach an out-of-court settlement than the revenue agents are. And the reasons are really not too mind-numbing. They basically get down to some human factors. First, these IRS Chief Counsel attorneys are simply less emotionally invested in the case than the original auditor. Second, their dockets are extremely full. If anyone has ever gone to a calendar call in U.S. tax court, it's literally, it can be a nightmare. There can be so many people in there that you are actually sitting elbow to elbow with, with people, and the IRS Chief Counsel attorneys have file after file. It's like a mountain of files on their desk, and usually there's only 2 or 3 of them there to handle all of the cases. So as you can imagine, they have an enormous incentive to settle as many cases as possible so as to avoid having to try every one of them. Third, IRS Chief Counsel is quite familiar and has to make themselves familiar with the hazards and costs of litigation, and they factor those variables into their negotiations. They have to always be cognizant of the fact that you know, that if a case that is particularly weak for them goes to trial and results in a published opinion that is contrary to them, that could be relied upon as precedent by a petitioner in a future litigation. So that could actually be the decisive factor in resolving the case. Knowledge on the part of the IRS Chief Counsel attorney that they have a weaker position than the taxpayer. When there's no agreed resolution, the matter proceeds to a bench trial. And yes, only a very small number of cases make it this far because it's essentially the bottom of a funnel. As I last statistics, I believe I don't have the most recent statistics, and I hesitate to quote any number, but I can tell you that from experience as a criminal defense attorney and being in the criminal justice system, that only about only about 4% of the cases, at least in the superior courts in New Jersey, go to trial. It's a very, very low, and obviously there are reasons unto their own in the criminal justice system because of mandatory minimums and you know, the risk of going to trial and being exposed to a far harsher punishment than the plea offer. But nonetheless, there are some parallels between our criminal justice system and the U.S. tax court in the sense of the number of cases that actually make it to this bottom of the funnel. If the taxpayer loses, he or she can appeal the resulting decision to the Court of Appeals for the circuit in which he resided at the time he filed the petition. And it's very important to recognize that because that does come up in some cases when the taxpayer loses. You know, they aren't happy, and they might feel that there are issues that could be appealed and that would be conducive to a fresh look by a panel of the Court of Appeals. And you need to know what Court of Appeals will be reviewing the matter because you want to see what precedent they have on the case and you know, how it's likely to be viewed based on their precedent. Step 5, if the taxpayer doesn't respond to a notice of deficiency by petitioning the tax court in the time allotted or by paying the tax outright, the IRS will make an assessment. An assessment is kind of the doomsday scenario. It is the end of the line, so to speak, because once the assessment is made, it becomes a debt of the taxpayer. I can't tell you how many times people have come into my office after the assessment, and there's not much that can be done. I mean, we can try to work out payment plans, we can try to work out an offer and compromise, an installment agreement, but as far as attacking or disputing the underlying tax liability, it's too late. The assessment's been made, and you know, that should have happened at an earlier time. Audit reconsideration is a good question. Yes, I have tried that on numerous occasions, and it really depends on the auditor that you're dealing with. I hate to sound so gray and nuanced here, and I wish I could give you a more precise answer. But really, it's so subjective that sometimes it comes down to the auditor that you're dealing with. You'll have an auditor that might really dig their heels in and might not give an inch, while you might have another auditor who is quite open to the arguments and you know, has an open mind. What I found is that the more time the auditor has put into it, the more personal it becomes, and the harder it is to get them to consider reconsideration. The IRS must give notice and demand for payment to the taxpayer as soon as practical and within 60 days of making an assessment. If the taxpayer refuses or neglects to pay the tax after notice and demand for payment is made, the amount of the tax becomes a lien on all the taxpayer's real and personal property until it is paid. Now, I want to make a slight digression here into eggshell audits. Basically, here's what I mean when I refer to eggshell. The IRS often audits taxpayers who, unbeknownst to them at the start of the examination, have major criminal problems. Now, the major criminal problem element is usually known by the client, him or herself, and sadly, in these cases, the CPA or tax professional representing the taxpayer is just recently enlightened on this by a nervous taxpayer who is breaking out in hives and is very nervous. This is usually how these things come to light, and the CPA is kind of in a situation where they are now stuck and they're trying to do damage control. The practitioner assisting such a taxpayer usually will have done his homework and ascertained that there is a problem and what the scope of the problem is. As I said before, though, it usually gets dumped on them by the taxpayer as soon as the notification of the examination comes up. So this isn't something where the tax practitioner is in a conspiracy with the taxpayer and knows all along that there's a fraudulent item on the return and has conspired or gone along with it. My experience is usually that this is dumped in their lap in the last minute, and again, the strategy becomes one of damage control. As we all know, a traditional source of criminal investigation referrals is the civil audit. Now, just a few obvious things here. It's too late for a voluntary disclosure if the IRS has already issued a notice that they're going to be auditing the taxpayer. So here are a few options that can be considered. In some cases, disclosure to the agent of what the fraudulent item is may be the best option. I'm not saying here it's always the best option. This is a very black and white, this is a very gray area rather. For example, when the practitioner can obtain a reasonable level of assurance by the civil agent that he or she won't refer the matter to CI, so that the disclosure of the fraud to the agent won't result in a referral, that might be an example where the practitioner wants to just come right out and advise the revenue agent, especially if the fraudulent item is one that is going to be found, and it's not a matter of if, but a matter of when. And even if it's subtle and and the fraudulent item isn't so obvious, disclosure to the agent may still be the best option. And you might be scratching your head now and saying, what did he just say? If it's not so obvious, still disclose? Well, again, I want to always, back up and tell you this caveat. Every case is different, and this is a very gross generalization. But what I'm saying here is this. At the end of the day, if the Department of Justice gets a hold of the case and decides to indict it on tax evasion, we all know that there is a heightened knowledge element for proving tax evasion, and that's affectionately known as willfulness. And willfulness is basically knowledge of having done or committed some wrongdoing. It has a very precise definition in the tax realm. To the extent that the CPA or tax professional has come out at the very beginning and disclosed to the agent that there is something that is something potentially fraudulent on the return, that can be used to argue that willfulness doesn't exist. It can essentially be used to gut the willfulness element by by arguing that, hey, we were forthcoming and honest right from the very beginning of this audit. We advised the revenue agent that there was an item that needed correcting, and we were fully prepared to amend the return and to comply with any instructions that the examiner gave us. So again, that disclosure at the very outset of the examination can gut the willfulness element to such an extent that CI may not be even interested in taking the case. Assuming the civil examination proceeds without making a full disclosure, you of course want to limit the contact between the agent and between your client, and this is for obvious reasons. You don't want the taxpayer getting on the phone with the agent or going in person to an interview with the agent, because of course things that are said by the taxpayer could potentially be used against him or her at a criminal proceeding. And there are, of course, a number of safeguards in place, not the least of which is the Fifth Amendment right against self-incrimination. So we want to protect our clients. And sadly, that scene from the movie that we all saw, I can't remember, it's going back a while, about 2 or 3 years ago, and it'll come to my mind. It was based on a true story, but in any event, DiCaprio was on his yacht, and he thought that he would be able to talk himself out of the problem that he was in, and the special agents from the FBI paid him a visit, and he not only got himself not only helped them solidify their case, but also gave them reasons to charge him with additional charges, because at the end of the day, he attempted to bribe the agents. Now, of course, that's an extreme example, but it's one that should resonate in our minds all the time whenever our client is in a hurry to try to get on the phone and explain things. And most of the time, that's what clients want to do. They want to explain their side because they feel that that they've done nothing wrong and that they'll clear everything up and that everything will be hunky-dory afterwards. But as we know, as attorneys and tax professionals, that's not usually what happens. What we also want to do is audit the agent. In other words, track the investigation to keep current on what the agent knows. I can't help but think of a bloodhound in this example, just, basically hunting down, birds or something. And, you always want to be hot on the agent's trail. You want to know what they know. You want to be in the know at all time. Oh, pheasant is what I'm thinking of. I have a Labrador, and my Labrador loves to go after birds, so birds were the first thing that came to mind. IRS civil agents have to notify the taxpayer before contacting third parties and to keep a record of the third parties contacted during the civil phase of an investigation. And Section 7609, which is really, really helpful to us as tax professionals, requires the IRS to notify the taxpayer of summonses issued to third parties. I can't tell you how many times this gets violated by the agent and how few agents actually know about 7609. Now, one should know right off the bat that the notice requirement is null and void in criminal investigations. And what you should also know, and this is how the IRS gets around the third-party summons requirement, is if the witness voluntarily provides information. So you'll have witnesses sometimes that are shaken up when they hear from a revenue agent, and they are so ready to throw your client under the bus or provide whatever information the agent requests that there's not a need for a third-party summons. And so what happens in cases like that is that statements or information provided by these voluntary witnesses may be sitting in a records room collecting dust in the agent's file, generally until it's requested by the defense. However, by establishing a good relationship with potential witnesses right from the get-go during the civil exam and asking these witnesses to call you if the IRS contacts them, that'll put you in the know a lot sooner than receipt of records via a FOIA request. FOIA requests, God, they take months to sometimes get to process. So I found that just notifying potential witnesses and asking them if they would let you know if they're contacted by the IRS goes a lot farther than, finding these things out through ambush. Now, if the agent issued a third-party summons and neither you nor the taxpayer received notice, that summons was probably issued incident to a criminal investigation, because like we said, it's that makes the third-party summons notice null and void. Second, issued with notice sent to the incorrect address, or third, issued in violation of the notice requirement. Now, what happens if the civil audit turns quiet? Well, a lot of people begin to panic right away, but it could mean a lot of different things. What I suggest is just pick up the telephone and contact the agent or the supervisor to find out what's going on without sounding like a nervous Nelly or, God forbid, tipping the agent off about anything nefarious. Understand this. I mean, at the end of the day, they're human beings like we are too, and the personal touch really goes a long way. I mean, I can't tell you how many times I've just, I've been unable to sleep because a civil audit turned quiet, and, I've probably lost, hours and hours of quality sleep, and at the end of the day, I just picked up the phone and I called and I found out that the agent was on vacation for 2 weeks. So you don't want to hit the panic button right away, and sometimes a little bit of time away to clear your head and come back to it will help you, will help guide you to, the most logical thing, which in some cases is just picking up the phone and talking to them. After the agent has completed the audit, they can take one of two directions. First, the agent may not perceive there to be any fraud, and they'll simply close the civil examination with proposed adjustments or a no change letter. It's very seldom that you'll get a no change letter. Second, the agent may determine that the case has sufficient criminal potential to be referred to CI, and this is the doomsday scenario. Now, although in theory the Internal Revenue Manual requires the agent to refer the case to CI whenever there's a firm indication of fraud, practically speaking, these agents are taught to consult with their group managers or fraud technical advisors to review the fraud potential. So it's not necessarily a hair trigger thing, or I would say a knee-jerk response, that whenever the agent determines that there's firm indication of fraud, protocol requires immediate referral. No, in practice, they're taught to consult with their group managers or the FTAs to review the fraud potential. So they're not in an isolation chamber when they're doing this. Again, they're usually bouncing it off of the sounding board, and the sounding board is their group manager or their FTA. So while a referral can occur at any time, it normally happens near the end. What type of cases are generally referred for prosecution? Well, let us back up and shed some light on the tax enforcement system. As we all know, it has limited resources. Coordination and prioritizing are essential to get the maximum bang for the enforcement buck. And Department of Justice Tax handles all tax trials in federal courts of the United States. It has the authority to approve all tax-related indictments. However, that doesn't mean that it actually tries every case. Some of you might have had tax evasion cases that were handled by the local office, U.S. Attorney's Office. Basically, DOJ filters the cases and determines which ones it's going to keep and which ones it's going to assign to the various regions. In New Jersey, we have basically 3 U.S. Attorney's offices. They're based in Newark, Trenton, and Camden. And my experience has been that I've had some tax evasion cases in those local federal courts that were not handled by a AUSA from DOJ Tax. They were actually handled by the AUSA in the local regional office. Again, DOJ Tax filters them and determines which ones it's going to keep and which ones it's going to delegate. And by the way, as you might imagine, there is a lot of pushback sometimes, and there is a lot of debate because by DOJ assigning cases arbitrarily sometimes to the various regions, and the regions themselves having their own priorities in terms of what cases to bring and what cases not to bring, you can tell that there is a certain tension that develops. And not surprisingly, the local regional offices don't generally have their AUSAs aren't generally schooled in tax law, and they're not always the most sexy cases to take. So as between a money laundering case and a tax evasion case, you can imagine that the head AUSA in the region is going to probably prefer to take the more sexy case, and in that case, it's money laundering because there's usually drugs involved and all sorts of sting operations. So DOJ's criminal enforcement section applies its investigative and prosecutorial resources strategically, and that supports the overarching goal of the tax system. And this comes right out of the book, preserving the integrity of this nation's self-assessment tax system through vigorous enforcement of the Internal Revenue laws. How does it do that? Well, it does that by prosecuting few cases each year. I believe in the last couple of years, the statistics have shown that anywhere from 2,000 to 3,000 cases have been selected for prosecution. And with that in mind, the attorneys, the U.S. Department of Justice usually focuses on the strongest cases in which conviction is highly likely, and they zero in on targets with a high profile, celebrities, yes, tax professionals, to make an example out of them, so that conviction will receive the maximum amount of publicity, encourage compliance, and heighten the deterrent effect among would-be tax cheats. The other thing that you will notice is that and this sounds a little underhanded, but the U.S. Department of Justice and federal tax enforcement authorities usually wait until around April 15th to announce these indictments. And you can fill in the blanks as to why. DOJ and the IRS accept the fact that there is a substantiality requirement for tax evasion, and this sometimes gets overlooked because it's not necessarily an element of tax evasion. In general, the IRS will recommend criminal prosecution under 7201, that's tax evasion, only if the average yearly additional tax for criminal purposes is at least $2,500 in specific items cases with uncomplicated facts, or at least $10,000 for the prosecution period in indirect method cases or cases with complicated facts. Now, I have to tell you that this is not adjusted for inflation, and these figures go back a ways. I want to say they go back to 2011 or 12. So I'm sure that these figures have gone up dramatically. And when I talk about specific items and indirect method cases, those are specific terms of arts that relate to reconstruction of gross income. I will be covering those in a separate seminar. Just if you have any questions, I believe that seminar is going to be held in or on May 17th, and I'll cover specific items and indirect method cases in more detail. Upon receipt of referral from CI, CES determines whether the case is within its prosecution enforcement priorities. So basically, everything starts with the referral to the to CI. CI is an arm of the IRS, and CI will make referrals to CES. CES has the discretion to decline the IRS's recommendation and return the matter to the IRS, either for further investigation or with instructions to close out the criminal investigation. I don't have stats for you on how many cases CES takes versus how many it declines. However, if CES approves a case, it usually forwards it to the U.S. Attorney's Office for the district where venue for criminal prosecution lies. And like I said, there's tension there. U.S. Attorney's offices have their own priorities, and they are overwhelmed with an enormous amount of cases. The last thing they want to be told or ordered to do is to take a tax evasion or tax fraud case that lacks the sex appeal of these other cases we talked about, and which in many cases their attorneys don't have the the knowledge and know-all to handle. As we know, these tax cases are complicated cases, and USD and DOJ tax are mostly, those prosecutors have a background in tax law and are LLMs and have, even been in the IRS before. That is not so true when it comes to the AUSAs working in the local U.S. Attorney's offices. They don't have formal tax training, and a lot of them aren't looking for any more work than the 100 other files that are sitting gathering dust on their desk. Privileges. I want to talk about this briefly. We can go into a full-scale lecture on privileges, but I just feel that we can't really do this topic justice unless we have a little bit of background on privileges. So Section 7525A1 of the Code, it covers the common law protections of confidentiality that apply to communications between a taxpayer and a federally authorized tax practitioner. So I want to set the record straight. There is a privilege that exists between communications between a taxpayer and a federally authorized tax practitioner. The reason you don't hear about it all the time is because the exceptions virtually swallow up the rule. But there is a privilege that exists. And for those of you wondering, what type of tax professionals fall under the federally authorized tax practitioner umbrella, it's all the ones you might expect, from actuaries to CPAs to enrolled agents. It's very liberal in terms of the number of tax professionals or the type of tax professionals that it encompasses. Now, this U.S. versus Arthur Young case started to chip away at the privilege between the taxpayer and federally authorized tax practitioners. It basically held that accountants' work papers are not protected from an IRS summons under the work product doctrine. And so, we're left scratching our heads. Well, if our work papers aren't protected from an IRS summons under this work product doctrine, what the hell is protected under the work product doctrine? Information and documents that are already in the possession of a tax preparer are not privileged, and the court held that they could be obtained by the IRS. Now, I feel terrible that I can't give you a more solid answer on what is protected, but right now we are in a state where the courts just have been eroding the work product doctrine, and I have to tell you that it really stretches my imagination to come up with what type of work product is protected under this work product doctrine. It exists. There's one that exists because there was a lobby that petitioned very hard, and Congress did pass it under 7525A1. I must admit I haven't been to that section in a while, and I'm sure that it will shed some light on what work product is covered under the privilege. But I can tell you that as a hard and fast rule, work papers are not protected. Now, the attorney-client privilege in the tax realm, I would use the phrase, it provides a more airtight privilege, one that is a notch above the preparer-client privilege. It protects legal advice and tax advice, but don't get too excited because in the next slide you're going to see how the courts have eroded that. However, where the advice is tax advice, the scope of the privilege is extremely limited. For example, there's no privilege for communications relating to investment or business advice or services. So let me back up now. This is the attorney providing advice to his client, who is the taxpayer. Second, the preparation of tax returns is generally not considered to be legal advice within the scope of the attorney-client privilege. So, let me give you this quick and dirty example. You're an attorney, a client comes to you, we'll call him John Doe. John Doe asks you for advice. If the advice that you give John Doe winds up on his tax return, meaning that the advice is related to a position that he or she takes on his or her 1040 or other tax return, that is not covered within the scope of the attorney-client privilege. So anything that could potentially result in a position that the taxpayer client takes on a tax return is not covered by the attorney-client privilege. And again, this states it more precisely. Any legal advice given by a tax attorney to his client that ultimately ends up on the client's tax return is treated as given as part of return preparation and is not covered by the privilege. In U.S. versus KPMG, and these cases are going back, I should also preface this by saying that these are circuit court cases. I don't know offhand what circuit this comes out of, the KPMG case, but I can tell you that circuit court cases carry extreme precedent, especially if the U.S. Supreme Court hasn't weighed in on the matter, even if it's not the circuit that your client taxpayer is in. In this case of U.S. versus KPMG, the court held that a tax opinion regarding the tax consequences of certain investment portfolio transactions was not subject to attorney-client privilege because the opinion was prepared in conjunction with preparation of a tax return. So I think you're beginning to see a pattern here. The slogan here, or the verbiage that's used, is in preparation of a tax return. Anything that can be reduced to preparation of a tax return or advice that is used for preparation of a tax return is not covered by the attorney-client privilege. However, we have this case of U.S. versus Frederick from the Seventh Circuit that thankfully takes a more nuanced approach to the privilege, and it's very refreshing. I just grabbed on to some language here that you might want to refer to if you're ever in a situation like this. And it comes from directly out of the case. It cannot be assumed that everything transmitted to the attorney by the taxpayer was intended to assist him in his tax preparation of a tax return and thus might be conveyed to the IRS. So thankfully, they realized, the court here, that information furnished to a tax attorney could just as easily have been offered by the client for the purpose of receiving legal advice. And I want to back up a little bit. When the courts use this slogan phrase, assist in tax preparation of a tax return, it's inferred that that any information that's on a tax return is going to be public knowledge because it's going to be shared with the IRS. And that's the rationale that the courts are using for gutting the attorney-client privilege. The courts are basically inferring that if the client is sharing information with the attorney, and if the attorney is providing advice that's going to be used by the client to take a position on the return, the client can't possibly expect that to be privileged, because the client knows that by the mere fact of filing the return, it's going to be seen by parties outside of him and his attorney. And so how, pray tell, could the client expect there to be any privilege if he or she is going to, be, relying on that advice by taking the position on a return that's going to be viewed by, a revenue agent and by multiple people in the IRS. So it's, akin to, this is not secret because it's going to be shared with a circle of people outside me and my attorney. And so how can a privilege attach in that case? Kovel accountant. We are all, I'm sure, very familiar with Kovel agreements. Well, let's talk about what a Kovel accountant is. It's an accountant that is brought under the cloak of the attorney-client privilege, which, as we've discovered, is a stronger privilege than the tax practitioner-client privilege, but doesn't really offer us as much comfort as we'd otherwise like. The Kovel accountant is, these are just some tips and some practical pointers. The Kovel accountant should be engaged as early in the process as possible in order to derive the maximum benefit from the accountant's work. If the budget permits, the strategy is to engage 3 professionals during an eggshell audit. First, the tax attorney. Second, the forensic accountant. And third, an independent accountant. And I'll discuss what each of their roles should be, because you can already imagine your client raising holy hell when he or she has to find out that they need to engage multiple parties, because naturally they're going to be worried about the amount of money that this is going to cost. And in most cases, the taxpayer is comfortable with the current CPA or tax professional they have, and so they'll question the logic behind bringing in other parties. But here's basically how the roles break down. The Kovel accountant would assist the tax attorney in gathering all potentially relevant information. The tax attorney would determine what portion of the information to disclose to the independent return preparer. So the attorney is pretty much acting as a gatekeeper, so to speak, by reviewing the information and determining what to turn over to the independent return preparer. In that way, while the independent preparer's knowledge is potentially discoverable by the IRS, the information disclosed to the Kovel accountant would remain privileged under the attorney-client privilege. So what we're doing here is keeping the roles of the original preparer and the Kovel accountant separate, and that best preserves the attorney-client privilege. Well, the question is why, or how does it do that? Well, if we were to use the original preparer as a Kovel accountant, this, and trust me when I tell you this, it's a recipe for disaster, because the risk is too great that the original preparer won't be able to distinguish between what he learned prior to the time that the privilege attached, the Kovel privilege attached, and what he learned after the privilege attached. As we've discussed earlier, information that the original preparer learned prior to the Kovel agreement being inked is discoverable, whereas information that was learned after the Kovel engagement was inked is protected under the attorney-client privilege. So, trying to distinguish between what was learned pre-Kovel versus post-Kovel, I can tell you is a nightmare, and the IRS knows that, and they exploit it to the highest degree whenever you are challenging a summons and the IRS is demanding that you turn over information. And even if you know instinctively and from your gut that this original preparer did not uncover or learn the information or produce the work papers that the IRS is demanding until after the Kovel agreement was inked, the mere fact that he or she is still the original preparer and still in the case will make it brutally difficult to to make the case in court that the information was obtained post-Kovel versus pre-Kovel. And it's a losing battle. And this is why it's so important to hire a second accountant, a forensic accountant, and get them involved in as early a stage of the process as possible so that we're not in this disaster, and we don't have to, be in a position where we're rowing upstream, so to speak. Moreover, and this is really the most damaging part because it hurts the client, the initial preparer already possesses enough information to provide a roadmap to the fraud, making him or her witness number one in the government's case in chief against the taxpayer defendant in a criminal prosecution. So again, the attorney should engage a Kovel accountant. These are ways of crafting an airtight Kovel agreement, and this might be counterintuitive, but just inking the Kovel agreement is not enough. I've seen Kovel agreements be torn to shreds. There are other things that need to be done to craft the airtight Kovel agreement in accordance with the Kovel case. And these are things that aren't as well known as the agreement itself. First, the attorney should engage the Kovel accountant and not the client. And I realize that this is going to create difficulty with record keeping and bill paying and what have you, and collecting, not the least of which, of course, from the client. But the attorney should engage a Kovel accountant. It's also recommended that the lawyer pay or at least approve the accountant's invoices. You're really okay if, so long as you're approving the accountant's invoices and acknowledging that the client can pay the accountant, but you want to engage the Kovel accountant directly. Second, a new accountant rather than the client's existing accountant should be engaged. The client, of course, will want his existing accountant for a number of reasons. The latest reason I've heard is that, he's a good friend and that, their kids grew up together and he's always invited to his accountant's 4th of July barbecue. I get it. I completely understand. But what we're really doing here is having or keeping the client's best interests at hand, knowing that things can go south. And the client doesn't know that because they don't know what's around the corner. They don't know what lies in wait. We do. And so what we're doing is, protecting the client from him or herself. Again, this could wreak havoc later on because it's difficult to distinguish between what the original accountant learned outside the Kovel agreement and what he learned within the scope of the agreement. Remember that only the latter is protected by the attorney-client privilege. Moreover, using the existing accountant requires additional steps be taken to ensure that the information garnered within the scope of the agreement is clearly separate. And this, again, is tedious and arduous. For these reasons, it's best to start fresh, hire an independent accountant right from the get-go. So that was a huge deviation into Kovel, into audits, and I apologize if that went in a different direction than what everyone was anticipating, but those are usually the questions that keep tax professionals up at night and that I get asked the most frequently. I do want to get back on track, though, with IRS Appeals, and what I've done here is just basically list some of the major topics that you will confront in IRS Appeals. The first is the role of appeals. So I want to give a little bit of background info on what appeals actually is, what their charter mission is, talk about the hazards of litigation, what does appeals consider, what issues can the taxpayer raise, give you an overview of the appeals process, give you the role of the appeals team manager, what if agreement is reached, what if it's not, independence of appeals and ex parte, non-docketed versus docketed cases. So here are the legal requirements. They're found in the Internal Revenue Code, they're found in Treasury regulations, all the fun stuff that we like to stay up at night reading, revenue rulings, revenue procedures, court decisions that consider tax disputes. This basically distills everything. I've tried to make this as least mind-numbing as possible and just give you what you need to know so that you don't have to stay up at night reading the Internal Revenue Manual and the court cases. The appeals employees must consider these following issues. Did compliance follow all required legal and administrative procedures? They have to consider issues raised by the taxpayer. For example, whether the notice of federal tax lien is appropriate, whether there are appropriate collections actions. And then they balance, and this is a catchphrase, they balance the need for efficient tax collection with the taxpayer's concerns about the intrusiveness of the collection action. I found that the latter is really lip service more than anything else. At the end of the day, the intrusiveness of the collection action usually gets thrown out the window. Hazards of litigation. What makes the appeals function distinct from the examination function? Well, appeals is uniquely positioned to recommend a resolution that is basically on a it's basically on this, not a scale, what is the expression I'm looking for right now? It's more or less a spectrum. It's on a spectrum of somewhere between fully sustaining or fully conceding the examiner's proposals based on the uncertainty of the outcome if the case was considered by a court of law. Now, what's interesting here is that, yes, the appeals officer actually has to have some knowledge about case law precedent, because otherwise, how would they be able to weigh or take into consideration the uncertainty of the outcome if the case was considered by a court of law? Now, it's a bit of an oxymoron because you'll find that none of the appeals officers have trial experience. They're not lawyers. Many have come from the examination division, yet they are still required to have some basic knowledge of the case law. And I will tell you up front that they don't. And it's your job to educate them on the case law. And by doing your due diligence, you will be amazed at how drastically their position can change. So never get discouraged just because just because an appeals officer appears to be siding with the examiner. If you can show in black and white, case law that supports your position or produce the evidence that was lacking at the examination level, you will be able to swing the appeals officer to your corner. And I've seen it happen more times than not. Most people throw in the towel way too early and just assume that the appeals officer is nothing more than an agent. And I can understand why, because they're an arm of the IRS, but again, their mandate is to, at least be, attempt to be impartial. So hazards of litigation, they're also comparing what examination does to what appeals has been granted the authority to do. Again, fair and impartial. This reflects mutual concessions. It's based on relative strength of positions where litigation uncertainty exists. In evaluating the hazards of litigation, appeals considers both factual hazards and legal hazards. There is a difference between the two. Factual hazards, when there is uncertainty as to the court's findings of fact. Factual hazards exist when there is either incomplete evidence or conflicting evidence. This evidence could be records or testimony of witnesses. Here's a quick example. The taxpayer may be claiming actual mileage as a business expense. The taxpayer presents documentary evidence that establishes odometer reading at the beginning and end of the year. These numbers determine total mileage driven throughout the year. However, during the examination process, the taxpayer told the examiner that he lost the business mileage log, so that the evidence needed to support business mileage deduction was incomplete. Conflicting evidence comes into play when the testimony of witnesses does not corroborate the same story. And in this case, what's interesting is that if the missing or if the smoking gun, the business mileage log, can be produced to the appeals officer at a later stage, they like tangible things, appeals officers, and if you can produce something physical to corroborate this business mileage deduction, you'll find that whereas it was denied by the examination officer, it will be granted by the appeals officer. Again, it's got to be physical, tangible evidence, and it's got to be the right type of evidence. In this case, if it's a lost business mileage log that has surprisingly been found right when the case goes to appeals, turn that baby over, because that could be the difference between whether you win or lose in appeals. And again, appeals officers are always looking for specific type of evidence, and by that, it's usually tangible and physical. Legal hazards, uncertainty as to how the court would apply or interpret law. Again, I can't stress, don't think twice about the importance of relying on case law at the appeals stage. Here we have a perfect example. The uncertainty as to how the court would apply or interpret law is a factor that the appeals officer has to consider. Legal hazards exist when there's conflicting case law, absence of legal precedent, conflict between the IRS's position on an issue and court decisions, ambiguity in an applicable statute or regulation, or conflicting law. So certainly present all the case law that you want to that supports your position. And what you want to be specifically mindful of when you're if you're relying on case law is that there are published opinions and unpublished opinions. Note that published opinions carry higher level of precedence in tax court as well as in any court than unpublished opinions. However, that doesn't mean that if you find an unpublished opinion that's favorable to you that you wouldn't want to bring it to the appeals officer's decision. I've certainly done so in the past with positive results. I've also had it shot down, but at the end of the day, there's no harm in trying. What's the worst that the appeals officer is going to say? It's an unpublished opinion and I'm not going to give it any moment. Well, then you move on. You know, you tried. What does appeals consider? Here's three main issues. Did compliance follow all required legal and administrative procedures? For example, was the notice of intent to levy issued in accordance with the law? Did the IRS notify the taxpayer as required that the notice of lien was going to be filed? Did the IRS issue the notice of hearing timely? The appeals officer will consider all issues raised by the taxpayer with the exception, of course, of taxpayer protest arguments, the ones that we seem to deal with a lot with our clients, moral, religious, or constitutional objections. Don't, even if you have a client that is insisting on raising these, don't do it. And the reason why is because you know better as a tax professional, but moreover, if you do this, if you raise these frivolous tax protester arguments, it's going to affect the credibility of arguments that otherwise might be very strong and where you have a strong position for. So it's the equivalent of raising an issue that has no merit and then, and throwing it to the wall, just to see if it sticks or just to appease your client, and then, attacking an issue that is that you rightfully have a strong position for and that is very winnable. You're not going to be taken serious. The examiner is going to think, well, this is just another, another frivolous argument that's being raised, or it's another fishing expedition that this attorney or tax professional's on. So it could affect and have a domino effect on the more weighty and more substantive arguments that are potentially winnable. And that's what you have to explain to your client. I found that if you explain it to the client, they'll understand and they will allow you to, put it to the side and focus on the issues that have the most merit. The appeals employee will balance the need for efficient tax collection with the taxpayer's legitimate concerns about the intrusiveness of the proposed collection action. What issues can the taxpayer raise? Well, let's start with the first. Any relevant issue relating to the unpaid tax or the proposed levy, including an appropriate spousal defense, an innocent spouse defense. Appeals will only consider challenges to liability if the taxpayer has not received a notice of deficiency or, second, otherwise had an earlier opportunity to dispute the liability before appeals. Example, if the taxpayer received a letter 1153 informing him or her of a proposed trust fund recovery penalty and didn't appeal at that time, appeals does not have the authority to consider whether the taxpayer is liable for the penalty during the CDP hearing. Other issues, second one is challenges to the appropriateness of the collection actions, and third, offers of collection alternatives. Section 6330 requires appeals to evaluate collection alternatives offered by the taxpayer, like a posting of bond, installment agreement, offers in compromise, and substitution of other assets. A basic requirement before appeals will consider alternatives is that the taxpayer has filed all required returns prior to the hearing. That's a very big caveat and one that sometimes is not met. So be sure to ask the client up front or to confirm up front that the client has filed all required returns. While appeals is considering the case, interest does continue to add up on any unpaid balance your client owes. And that's a conversation you want to have right from the get-go and maybe even memorialize in writing, because you never want to have the client coming back and accusing you of not having advised or informed them that interest was accruing on the unpaid balance throughout this entire process, which can sometimes go on for months and months and months. Overview of the appeals process. The appeals receives cases from all four divisions, as you can see. These are the sources of their cases. Generally, disputed tax cases come from the compliance function within these divisions, like exams or collection. Within each function, the field offices or campus offices work up the entire spectrum of cases relating to it. So appeals receives cases both from the field and from campus sites. How to request an appeal depends on the source of dispute. Since appeals is separate and independent from compliance, the taxpayer must first request an appeal to the office that proposed the original determination or specific collection action. Appeals will receive a complete administrative case file that includes the client's position and the government's position. Second, in tax disputes generated as a result of an exam of your client's return, the taxpayer must submit a written request to the examination office that reviewed the return. In cases where the dispute is less than $25,000, no formal protest is required. And third, for collection issues, it depends on the type of collection dispute. Some of the commitments that appeals makes is it will explain to your client his or her appeal rights and the appeals process. It does so usually in a 4 or 5 page letter that is written in very plain English and easy to understand. Nonetheless, you do want to sit down and explain in detail to your client. It'll listen to your concerns, be courteous and professional, be responsive, and be fair and impartial. They do have expectations. The expectation is that taxpayer will listen to appeals explanation of the appeal rights and the appeals process. It'll give appeals a statement as to how the taxpayer understands the facts in the law, listing all issues with which you disagree and why. The taxpayer will give appeals any additional information or documentation that supports their case. Taxpayer will tell appeals when and how they think the case should be resolved, and let appeals know the best time to contact you. It's very informal. As we know, the conferencing options usually are, they do state that face-to-face correspondence is still an option, but I found more so today than at any other time. It's usually a telephone conference that the appeals officer has with the tax professional, and that's after the appeals officer has received all the documents in the case, the file from the examiner as well as the taxpayer's documents and position and arguments and their entire file. That's when they'll get on the conference call with you. The appeals team manager does have a role. He or she will approve the final outcome of the case. Appeals employee will make a recommendation to the appeals team manager, including whether or not an agreement has been reached. The appeals manager will review the file and approve the case if the settlement is appropriate, or return it to the appeals officer if additional work or consideration is needed. If agreement is reached and the client doesn't owe anything or a refund is due, the tax preparer has nothing else to do. If there's a refund, the campus will send it to your client. If the taxpayer owes some amount, they have some payment options. Taxpayer can pay a few different ways. They can pay the full amount due outright. If the taxpayer can't pay the full amount due at once, he or she may qualify for a payment plan. If the total amount is under $25,000, the taxpayer qualifies for a 60-month payment plan. If the taxpayer doubts that he can afford to pay the full amount, even under a payment plan, and he has filed all required returns, he can consider submitting an offer in compromise. And if that offer is accepted, he or she may pay a lesser amount than what he owes. If the taxpayer does not reach an agreement with appeals, the appeals officer will inform the taxpayer as to any further options he or she may have. If the taxpayer requests an appeals conference and the parties don't come to an agreement, the IRS will send the taxpayer a notice of deficiency. A notice of deficiency is also considered the ticket to tax court because it basically gives the taxpayer two options, and in many cases the taxpayer doesn't really consider any of these options because it's kind of cornering them to one of two things. And the first is to reluctantly pay the asserted deficiency and follow the refund procedures, which are explained. Or second, petition the tax court to contest the claimed deficiency within 90 days of the date the notice was mailed. While the taxpayer does have that second option of petitioning the tax court, what usually happens is, the smart taxpayer, does a balancing and knows that petitioning the tax court is going to cost money in the form of hiring a a tax attorney or paying his or her tax professional more money to file the petition without any guarantee that they will win. And so what they wind up doing is balancing to determine, whether, it's even worth going forward. Is the money that I'm going to pay my tax professional, worth, taking this gamble, or should I cut my losses and just pay the asserted deficiency? And in some cases, the cost of hiring the attorney is even more than the asserted deficiency. So, in those cases, the taxpayer might just cut his or her losses and reluctantly pay the asserted deficiency. And so, again, while on paper it looks like there are two options, the practical reality is that generally there's only one option. And while the taxpayer is really miffed and is incensed and wants to file that petition and go to tax court, once they have some time to digest all of all that goes into that and how this is going to cost more money, they usually rethink it and wind up reluctantly paying the asserted deficiency. The mailing of that notice begins a period during which the IRS cannot assess tax. If the taxpayer petitions a tax court, this prohibited period continues until the tax court's decision is final. And again, the independence of appeals and ex parte cannot be stressed enough. The mission is to resolve these controversies without litigation on a basis that's fair and impartial to the government and to the taxpayer. Well, how can appeals demonstrate it's fair and impartial to both parties to the dispute? After all, the appeals employees works for the IRS. And it's a circular thing. It gets back to this idea that their mandate and their charter is to be impartial, and that their whole integrity depends on their ability to remain fair and impartial. Congress basically recognized this need for appeals independence when it passed the 1998 Restructuring Act, and they basically put in it chock full of language, this idea of independence of appeals to give the public some confidence that their cases were going to be viewed impartially. Now, these are some of the ex parte rules that do bind appeals. First, there can be no discussions about substantive case issues between appeals and compliance without inviting the taxpayer to participate. So the appeals officer can't get on the phone with the examiner and have a conversation. I would go so far as to say even a casual conversation about a document that might be missing in a file. I would put their feet to the fire if I ever found out that there was, even a 30-second conversation between appeals and between the examiner. If you haven't been invited in to participate, how do you know what was discussed in that call? Maybe the examiner in those 30 seconds told the appeals officer that the taxpayer is full of crap and the attorney is a fraud. I mean, you don't know what was said, and I would say that while the specific language says substantive case issues, I think that there can't be any such thing as a discussion between appeals and an examiner that isn't substantive. So, I would argue strenuously if it ever was revealed that there was an ex parte discussion between appeals and compliance without your being invited in. If the taxpayer provides new information to appeals, appeals asks the examiner for their opinion in writing and shares their comments with the taxpayer. So any new information that's furnished to appeals will, as a matter of course, be furnished to the examiner, and the examiner will have the opportunity to weigh in. When there's need for further clarification from the examiner, appeals officer may contact the taxpayer and invite the taxpayer, and usually it's the taxpayer's counsel, to participate in a conference call or meeting with them about the new info. And third, the law includes discussions with IRS chief counsel attorneys about non-docketed cases.
If appeals needs advice about an issue, it must be given by an IRS chief counsel attorney who did not provide advice to the compliance employee. So there's a number of issues that this raises. Non-docketed cases just means that it's through a protest, and that there's two ways of getting to tax court. Or getting to appeals rather. One is by filing the protest. The other is by bypassing the filing of a protest and filing the petition. In most cases, if it's under a certain amount, tax court is going to ship it back to appeals and try to get the parties to negotiate some type of settlement with appeals, even if the taxpayer didn't file the protest and automatically made petition to the tax court. And so if the case if the case is automatically protested without a petition being filed, and then the tax court saying, we're going to send it back to appeals, that's non-docketed. Non-docketed, again, in the case of where a protest is filed. If an examiner has had a discussion with IRS chief counsel attorney, it is imperative to understand that the appeals officer, if he or she needs advice about an issue and needs to consult chief counsel, they cannot consult the same IRS chief counsel's attorney that the examiner consulted with during the exam. They have to go to a different chief counsel attorney. If an appeals employee believes it's necessary to talk to a previous IRS chief counsel attorney regarding an issue, the taxpayer or his or her representative must be given an opportunity to participate in that discussion. And I know what a lot of you are asking yourselves right now, if these ex parte discussions happen, how the heck are we even going to know about them? Well, that's the whole thing. The practical realities of the situation are that this could be going on behind our backs without us even knowing. So it's always important to do your due diligence, but there are, certainly things that happen behind the scenes. But I will say this, while this rule against ex parte discussions sounds really good and sounds very helpful and friendly to the taxpayer, there's really no teeth in them, because it doesn't really say what happens if, this does happen. And what is the recourse? Is the appeals employee sanctioned? Is the appeals employee suspended? Is the appeals employee fired? What the heck happens if this is violated? And, I think that there's going to be case law that we see that comes down in the years to follow. But so far, nothing. Exceptions to the ex parte rule: the administrative file itself, developed by compliance and forwarded to appeals, does not violate ex parte rules. So if the file itself, all right, the sharing of the file itself between the examiner and the appeals officer doesn't violate the rule. Since the administrative file contains the proposed determinations and the protest filed by the taxpayer, it sets forth the boundaries of the dispute, and this forms a basis for appeals to assume jurisdiction. Where contact with compliance relates to administrative, ministerial, or procedural matters, again, that is an exception. Well, that's a whole thing. What's an administrative, ministerial, or procedural matter? I'm afraid that will sometimes, if the appeals officer is ever confronted, or is ever alleged to have violated the ex parte rule, they would probably rely on this exception. And so how broad is it? Is there case law that covers it? And there might very well be some case law, a body of case law that's out there that we can find. Where the communication is needed to understand an individual's handwriting, well, now we're getting into some really absurd things here. If the taxpayer's representative has been offered the opportunity to participate in a discussion between appeals and compliance, but unnecessarily delays responding to that opportunity, the ex parte rules won't apply. Delay must be beyond a reasonable amount of time. What is a reasonable amount of time? Well, we need to turn to case law and see how that is defined. Do the ex parte provisions change the appeals policy regarding raising new issues? No. Appeals still has a right to raise new issues, but it doesn't do so often. New issues are really never raised casually or, haphazardly by an appeals employee, and they're never raised for bargaining purposes. To raise a new issue, it must be substantial, and potential effect on the tax liability must be material. We covered non-docketed. These are appeals made on a protest basis in response to a 30-day letter. This means that the tax court does not have jurisdiction over the taxpayer's dispute. Docketed means if taxpayer petitions the tax court without having had a conference with appeals, it's considered docketed because, yes, it's in the queue in tax court. It's just that tax court wants it to be wants there to be some attempt made to resolve the case in appeals. If appropriate, Chief Counsel may forward the case to appeals, and if appropriate, there's a few factors that factor into that, and I know we have a new sweeping body of regulations now that are saying that there has to be petition filed before the taxpayer can even get to appeals, and I'm going to discuss that in the next one or two slides. But for now, I'm just covering some meat and potatoes issues regarding this non-docketed versus docketed. So again, if appropriate, Chief Counsel may forward the case to appeals. And I misspoke before. I said U.S. Tax Court may kick it back to appeals. No. IRS Chief Counsel has the discretion to forward the case to appeals for purpose of reaching the negotiated settlement prior to the case being heard by tax court. However, if appeals and the taxpayer are unable to reach a settlement, then the court will ultimately decide the taxpayer's dispute. That's normally when we get called into court for a calendar call. Well, there's different types of non-docketed cases. I'm not going to go into all of these right now. And as we discussed earlier, the taxpayer does have the right to appeal an adverse U.S. Tax Court decision to the Circuit Court of Appeals for the circuit within which the taxpayer resided at the time he filed the petition. So as far as strategy goes, you want to know if your taxpayer, for example, lives in New Jersey, what the Third Circuit's position is on the issue that's being in dispute, and as well as what the U.S. Tax Court case law precedent. So basically, without getting into too much detail here, let's say, for example, you have a taxpayer who resides in the state of New York. And that is considered the Second Circuit, Manhattan, New York, Midtown, Uptown, what have you. Let's say that the petition is filed in the New York Tax Court. Well, here's the deal. If there is a published opinion in the New York Tax Court that governs the issue that the taxpayer is disputing, that will carry the weight or carry the day in terms of how the court views that issue and ultimately decides it. If there is no published case law precedent in New York U.S. Tax Court on that issue, then the precedent will be governed by the Second Circuit, because that is basically the circuit where the taxpayer resided at the time he filed the petition. So you want to know what circuit is a governing circuit, because in the event that there is no case law directly on point, published case law directly on point in the tax court that you filed the petition in, it's going to be the circuit for which the taxpayer resided that actually controls legal precedent in the matter. And that differs, of course, from how criminal matters are looked at in appellate circuit courts, but I want to stay away from that because it gets very confusing. But just note well that when you file a petition in a certain tax court, you want to know whether that tax court has published case law precedent on the issue. And if not, look to the circuit where the taxpayer resided, because it might be different from the area where you've, or from the town or city where you filed the tax court petition. So you could have a client in Virginia, for example, and the tax court petition is filed in New York. Well, if New York doesn't have published case law on the issue, then the court is actually going to turn to the circuit where the taxpayer resided, Virginia, to determine what the case law is, or if there is any case law out of that circuit on that issue, and that would govern. It gets very, very confusing, and so these things have to be figured out ahead of time. Transfer and conference procedure, changes in appeals. Yes, this is what I was getting to earlier. Appeals has implemented changes to its case transfer and conference procedures. Previously, in cases where a face-to-face conference was requested, appeals allowed automatic transfer from the campus to field offices. However, after reviewing this procedure, IRS discovered that taxpayers often requested case transfer where a campus employee could have resolved the case. In addition, there were added costs for shipping as well as a delay. Another consideration was that many of these transfer cases were ultimately resolved by a telephone conference. The change is that appeals will not transfer cases based only upon the taxpayer's request and will consider a number of factors before an in-person conference is granted. The hearing officer makes the initial determination to grant an in-person conference, and the appeals team manager will make the final decision. The manual, Internal Revenue Manual, has been updated to reflect these changes. IRS collection methods. We are all very familiar with them. I mean, just to give you a broad overview, they range from installment agreements to offers in compromise to levy actions. Installment agreements and offers in compromise, of course, give some more power to the taxpayer, whereas the levy action is an outright seizure of property, such as cash, wages, or bank accounts to satisfy a debt. And once we get to levy action, there's not very much we can do except make very strong pleas and attempts to forestall the inevitable from happening. And usually the inevitable happens unless the money can be produced according to the terms of the IRS. And in many cases that means a heavy lump sum payment now as opposed to 6 months from now. So the IRS is very serious when matter has escalated as far as a levy. Filing a notice of federal tax lien. Basically, a lien gives the government a claim to property, a security, or payment for a tax debt. Notice of federal tax lien notifies the public that the government has such a claim. During appeals consideration, what happens with the collection action? Levy action is suspended during the period of time that appeals considers a taxpayer's request for a CDP hearing relating to a notice of intent to levy. In equivalent hearing cases, collection can move forward on levies if the IRS determines that collection of tax is in jeopardy. Generally speaking, the quick and dirty rule is that if collection is ever deemed in jeopardy, meaning the IRS fears that the taxpayer is slippery and is going to move money offshore or do something underhanded that will jeopardize collection attempts, all bets are off for for abeyance or for postponement of or suspension of levy action. If anybody has any questions, always feel free to reach out for me. A lot of issues are, issues that do require research. And I can tell you right now that a lot of the topics that we talked about have come from a lot of years of experience and a lot of just hard research and pick and shovel work. It's something that I enjoy, and I'm more than willing to help you out with if you have a question that comes up that I don't have a ready answer for. So many of these cases really depend on the individual facts and circumstances, and it's so hard to do a presentation like this because you want to make it as general as possible for as broad an audience as possible, but we all know that, you know, cases turn on sometimes one solitary fact, and everything really is, you know, based on a very thorough analysis of the facts and circumstances. So again, it's been a pleasure presenting. Thank you for your participation, and I look forward to seeing you in next week's webinar.